Okay, can you hear me now? I'll try that again. Thank you, everybody, for being here tonight. Appreciate the turnout. Our first item is an approval of the agenda. Mike, would you help us with that?
I make a motion that we approve the agenda for the February 25th, 2025 Planning Commission meeting.
I will second that.
May we have a vote, please? All in favor? Thank you. All in favor? Passed unanimously. Thank you. Our next item is approval of minutes from our last meeting.
And I make a motion that we approve the minutes for the January 28th, 2025 minutes as stated.
Thank you. A vote? Aye. All in favor? Aye. Approved unanimously. Thank you. And yes, we have a lot of paperwork, so bear with us. I'm going to spend a minute and read something to you, and I'll appreciate your attention. I can hug the microphone. Does that help?
Yes, do it.
All right. Thank you. Oh, okay. That means I got to hold this over here. No. All right. Good evening, everyone, and thank you very much for your attendance at tonight's meeting. I also want to thank you for the efforts made to inform us of varying perspectives and points of view, all of which help us better consider and understand the issues at hand.
I make a motion that we approve.
Please be assured that the applications that come before the Planning Commission for review and consideration have already gone through a highly detailed and incredibly tedious process that has been affected by our Planning and Development Department. These meetings provide an opportunity for public exposure and comment, whether for or against.
And I make a motion that
in order to assure that everyone has an equal opportunity to be heard and to minimize distractions, I will now ask you to silence and or turn off your electronic, any communication devices, phones, etc. Approved unanimously. For the remainder of this meeting. On the other hand, if you are a doctor on call, you can leave your phone on, okay? Please note that this is an official public meeting at which important city business is conducted and that we are herewith engaged in a legal process. I'm going to spend a minute. Let me now review the procedures we will follow for tonight's meeting. The Director of the Planning and Development Department, Jason Thompson, who's sitting right over there, will begin by first presenting to all of us an overview of the project and the specific request being made by the applicant. That means I got to hold. He will then respond to questioning from the Commission. Good evening, everyone. The applicant will then be afforded 15 minutes to make their presentation. I also want to thank any allotted time not used for that presentation will be reserved for rebuttal if necessary, all of which help us better and to respond to questions and concerns as voiced by you, the public. Please be assured upon completion of the applicant's presentation, we will open the floor for public comment. Have already gone first to those wishing to state their support for the project, and then to those who claim opposition. That has been affected by a total of 15 minutes will be allotted for all these meetings public comment and opportunity. Accordingly, please be focused and direct with your comments, so that others are also able to speak. In order to assure that everyone has, if there are common concerns, hopefully you minimize distractions, utilizing a spokesperson. And or turn off your. By remaining in this room at this meeting, the public hereby agrees to the remainder of this meeting. Outcries, clapping, whistling, and any other form or method of demonstrative behavior is neither allowable nor acceptable. Please note that this is an official public refrain from doing so. At which, when you come forward to the podium, please speak directly into the microphone, which you've asked me to do. Let me now review the procedures so we can follow for tonight's meeting. The first thing we want you to do is give us your name and address for all to hear. Jason Thompson, who's sitting right over there. You will then direct your comments to myself and to the other commissioners. Of the project, not to the applicant and not to anybody else in the room. Made by the applicant. You may only speak once regarding the particular application that we're working on, so please be as precise, thorough, to the point, and prompt as possible. For that presentation, kindly present your comments in a fair and reasonable manner, and be sure to focus only on the topic or issue at hand. Be mindful that anger and poor attitudes serve no purpose and have no place in these chambers. Again, please be as brief and to the point as possible, keeping in mind the time limits we are working with, knowing that there may well be others who also wish to speak. If commission members ask questions of you, it will not be deducted from your allowable time. Upon closing of the public comments, the applicant may, as previously mentioned, use their remaining time for rebuttal and response. A commission member will then offer a motion, and I will request a second to that motion. If the motion carries, discussion among us commissioners will ensue, if appropriate or necessary, after which time a vote on the matter will be called. Again, I sincerely appreciate your attendance and your participation. Let us proceed then with the business before us. I will now ask Jason Thompson, our Director of Planning and Development, to introduce the case before us and to provide an overview. So we can hear you. The first thing we want you to do is give us your name and address for all to hear. You will then direct your comments to myself and to the other commissioners, not to the applicant and not to anybody else in the room.
That's fine.
You may only speak once regarding the particular application that we're working on, so please be as precise, thorough, to the point, and prompt as possible. Kindly present your comments in a fair and reasonable manner, and be sure to focus only on the topic or issue at hand. Be mindful that anger and poor attitudes serve no purpose and have no place in these chambers. Again, please be as brief and to the point as possible.
Thank you, commissioners. Thank you, public, for coming out tonight. We have one single item on the agenda tonight.
Who also wish to speak.
It's finally here after a couple of revisions and postponements, but we're here. It's rezoning 24-04 in the Associated Land Use Plan Amendment Request 24-02. Again, this is a rezoning and a land use plan amendment for Green Turf Drive and Classic Drive. It's approximately 95 acres.
Discussion
on
among
tax parcel
us
5093106 is currently zoned RS30 with a requested zoning
on the matter will be called. Again,
of
I sincerely
RS5
appreciate your attendance
and a
your
current future land use
participation.
plan of park and
Let us proceed then
recreation,
with the business before
which
us.
was
I will now
the
ask
golf
Jason
course
Thompson,
to
our
now
Director of Planning and
proposed
Development,
for residential
to introduce the
low
case
density,
before us and to provide
150
an
single
overview.
family detached residential subdivision with open space. The property owner is Summit Chase Country Club Incorporated of Snellville, Georgia. The applicant is KJ Luxury Homes, who is here represented by Shane Lanham of Mahaffey, Pickens, and Tucker. And the initial recommendation is approval with conditions. Just go through the facts of the case. We've received an application for the project that I just kind of reviewed. The applications were originally scheduled for consideration October 2024, or October 22, 2024. It's been tabled and postponed till now, till February 26th.
Thank you, commissioners. Thank you, public.
The site
for
formerly
coming
served
out
as the
tonight.
Summit
We
Chase
have,
Golf Club
one
and Country
single
Club,
item on the agenda
developed in the
tonight.
mid-'70s and includes
It's,
the back nine of
finally
the
here
golf
after a
course,
couple of,
driving
revisions
range,
and
clubhouse,
postponements, but we're
swimming
here.
pool, tennis
It's,
courts,
rezoning
drive range, I
24-04
think I already said
in
that,
the
car barn,
Associated Land
maintenance
Use
building, and
Plan
surface
Request
parking. Again, the applicant intends to
24-02.
develop
Again,
150-foot lot,
rezoning and
single-family
land use plan
residential
amendment for Green
residential
Turf Drive
community
and
with a
Classic
gross
Drive.
density
It's
of
approximately
1.5
95
lots
acres.
per acre
Tax
to
parcel
incorporate 27 acres of open
5093106
space and
is
recreational
currently
area,
zoned
including
RS30
tennis
with a
courts, swimming
requested
pool,
zoning
clubhouse, and other amenities. The
RS5
proposed development is
and a
1
current
mile
future land use
from
plan of park and
less than 1 mile
recreation,
from Athens Highway,
which was the
and also
golf course
has
to
a
now,
entrance and egress
proposed
over
for
on
residential
Rosebud Road.
low density.
The land use
150
plan
single family
proposes to the comprehensive,
with
or
open space. The
the
property
applicant
owner is
proposes
Summit
to
Chase
amend the
Country Club,
2045 comprehensive plan
Incorporated
future
of
land use
Snellville,
map
Georgia. The
from
applicant
parks and
is
recreation
KJ
to
Luxury
residential low
Homes, who
density.
is here represented by Shane
Which
Lanham
is,
of Mahaffey,
is the
Pickens,
maximum
and Tucker.
density is
And,
3.99
initial
lots per acre.
recommendation
The
is approval with
1.57 meets the
Just go through the
standard
facts
for
of the
that. It's
case.
below. And
We've received
it
an
places the
application
entire
for the,
proposed
project
development
that I just
in
kinda
the Summit
reviewed. The
Chase character area,
applications
which consists
were
primarily of
originally,
low-density residential
scheduled for
developments,
consideration
state development,
October
and
2024,
park and
October
recreation
22,
land use.
2024.
If you
It's
look
been tabled
here to the
and
south
postponed
or
till now, till
southeast,
February
where you
25th.
see the paths,
The
that's
site
where
formerly
Soleil
served
of
as the Summit Chase Golf
Snellville
Club
was
and Country
approved
Club,
probably about 5
developed
years
in the
ago
mid-'70s
for
and includes the back nine
a
of the
similar
golf
type
course,
zoning, was
driving
RS5,
range,
smaller
clubhouse,
lots, but was
swimming
also
pool, tennis courts,
age
drive
restricted.
range,
55 plus, and the development actually
Again, the applicant
crosses
intends to
Rosebud
develop
as well. The
150-foot lot,
initial
single-family residential
first few phases
residential
are under development
community
and
with a
been
gross
completed, and there are
density of
actually people living in there
1.5
for a little
lots
bit of
per acre to
background.
incorporate 27
Once
acres
that
of open
development
space
was
and
put in
recreational
place,
area, including
basically
tennis
at that
courts, swimming
point,
pool,
Summit
clubhouse,
Chase
and other
closed.
amenities.
There's no
The proposed development is
the
1
business
mile
closed, and
from
we've been left with
less
kind of
than
what's
1
been
mile
there
from Athens
in
Highway,
regards
and
to
also
the golf
has a
course,
entrance and egress
what's
over
left
on
of it
Rosebud
and the
Road.
vegetation
The
around
land use
it.
plan, the Summit Chase
proposes
character
to the
area is
comprehensive-
predominant land
the
uses are
applicant
low
proposes
density
to amend the
residential,
2045
estate residential, and
comprehensive
park and
plan future
recreation
land use
map.
Parks
Key
and
implementation
recreation to residential
implementation
low density.
strategies address code enforcement
Is-
violations,
which is,
strengthen
the
the neighborhood
maximum
watch
density is
program,
3.99
multi-use
lots per
trail
acre,
along
1.57
Big Hands Creek,
meets
preserve green space and wooded
the
areas, protect the
standard
Big
for
Hands
that's
Creek
below,
watershed, and focus on reinforcing
it
neighborhood
places the
stability
entire
by
proposed
encouraging
development
more homeownership
in
and
the Summit
maintenance
Chase
or
character
upgrade
area,
area,
which
which
consists
consists primarily of low-density residential developments, state development,
residential low density
and park
project
and recreation land
residential
use
low density
area. Let's talk about the site plan a little bit.
Southeast,
It shows
where you see the
the
path. That's
RS5
where
district
Soleil
that the
of
request is for
Snellville was approved
is
probably about 5
areas
years
where
ago
you want to
for,
provide
a similar
market-driven,
type
high-quality,
zoning.
small
RS5 was
lot
smaller lots, but it
homes.
was also
The minimum here is 5,000.
restricted.
It should be
55 plus,
noted that
and
the applicant,
development
if you look on the
actually,
lot sizes graph,
crosses
has
Rosebud
proposed
as
no
well.
lots
The
less than
initial,
10K or 10,000
first few
square feet,
phases are
and the
under
bulk of them
development,
are
have been
between
completed,
10
and are
and
actually people
15,
living in there
with a
for a
few
little bit of
upwards to 21,000
background.
square feet.
Once that development
The
was
project
put in place,
summary sheet indicates a
basically at that
65-foot
point,
minimum
Summit
lot
Chase
width,
had
45
closed.
maximum
There's no,
lot coverage, and 40-foot
the
minimum
business
front yard
closed, and
setback.
we've
It
been left
also
with kind of what's been
declares
there,
that the
in
minimum lot
regards
size will be
to
10,000
golf
square
course,
feet and not
what's left
5.
of it and the vegetation around it.
There's
The Summit
31
Chase character area is
31-foot wide
predominant land
streets,
uses
5
are
stormwater
low-density
ponds.
residential,
There's
estate
also
residential,
a
and park and recreation.
the applicant added
The
the
revision,
revision,
and I know it's hard to
implementation
see on the
strategies,
screen, but
address code
aware that there's a
violations, strengthen
35-foot
neighborhood
buffer
watch
around the
program,
exterior of the
multi-use
property that
trail
is
along Big
not
Hands Creek,
required by the
preserve
code,
green
but
space and
placed
wooded
there
areas,
after
protect the Big
concerns
Hannes Creek
were heard
watershed,
from the
and
citizens
focus
in the
on
area.
reinforcing neighborhood stability by encouraging more homeownership and maintenance or upgrade of existing properties. Here's some of the existing building elevations. So key point,
project.
one of the original
residential
issues
area was the access.
Talk about the site plan a
and
little
ingress and egress into it, where
It
most
shows
of it was running through
the
this
RS5 district
abandoned,
that the request
still
is
there,
for
cart path.
is areas
Easement.
where
There's
we want
actually
to
some
provide
right-of-way, it looks like.
market-driven, high-quality,
After,
small
speaking
lot
with the
homes.
applicant,
The minimum here
and
is
hearing from the
5,000.
residents,
It
it was
should be
desired that there be a more
noted
central
that the
ingress and
applicant,
egress, and that
if you look
ingress
on the
and
lot
egress is
sizes
now
graph,
coming out.
has proposed
there
no
to, I
lots
believe
less
that's
than
Classic
10K
Drive,
or
in front of the
10,000 square
existing,
feet, and the bulk of
amenity
them
area
are
and
between
country
10
club
and 15,
building
with a few
an
upwards to
emergency
21,000
entrance only
square
to the
feet.
north with a Knox box for
The project
to be
summary
used
sheet
for fire
indicates a
safety,
65-foot
which
minimum
is
lot width,
required
45
per,
maximum
Gwinnett
lot
County
coverage,
fire
and
when you have
40-foot
over a certain
minimum
amount of homes.
front yard
So that's
setback.
there,
It also
to serve
declares
that.
that
Really
the
the
minimum
key,
lot size will be 10,000 square feet.
highlights of
and,
the plan.
not
There's some
5.
different green spaces, dog
There's
parks, and,
31
other amenity
foot
areas
wide
spaced
streets,
throughout
5 stormwater ponds.
There's also
Some sample
a,
elevations, not necessarily
added the revision,
what's going to
and I
be
know it's
built
hard to
here
see
on the screen,
custom
but
homes,
aware that there's
anywhere
a
from, I believe,
550
$550 around the exterior of the property
I'll allow
that's,
the
not
not
required
required
by the code, but it's placed there after concerns were heard
from the citizens in the area. And outside of that, we recommend approval for the LUP, approval of the
Here's
rezoning,
some
and
of the
I'd just like to
existing
read
building
the
elevations.
conditions
Key point,
as proposed into
one of
the
the
record, so
original
we have them.
issues,
The property shall be
was the
developed in
access,
accordance with this
and
conceptual
ingress
site
and
plan
egress into
entitled
where most
Master
of it
Plan
was
for
running
Summit
through
Chase
this
West, dated
abandoned,
8/15/2024, revised
There's actually some right-of-way, it
1/30/2025,
looks like,
stamped received January
after,
31st,
speaking
2025, with
with the
modifications
applicant,
permitted to meet
and hearing from
conditions
the
of
residents,
zoning
it was
or
desired
state
that there be a
county
more
and city
central ingress and
regulations,
egress, and that ingress and
substantial
egress is
variation
now
from the
coming out,
conceptual rezoning
there
site
to
plan
conclude.
as
That's
determined by the
Classic Drive,
Director of Planning and
in front of
Development
the
will
existing,
require mayor and council
amenity
approval.
area and
Building
Country
setbacks are
Club
stated front
building
yard
with
40,
an
rear yard
emergency
30,
entrance
side and
only to the
interior
north
yards
of the
10,
Knox box
and
for-
street
to
side,
be used for fire
basically corner
safety,
25,
which is
maximum
required
lot coverage
per, Gwinnett County
45%.
Fire when you
All
have
driveways
over a
shall be a
certain
minimum
amount.
of 22
So
feet in
that's there.
length, measured from the front of the
So
garage
that's
to
really
the edge of the
key.
sidewalk closest to the dwelling, and shall be
Highlights
enough
of
to
the plan.
accommodate
There's
the
some
parallel
different
parking
green
of 2
spaces,
vehicles.
dog
Developer is
parks
to, number
and,
4, developer to provide an
other
emergency
amenity areas
access
spaced
gated
throughout
connection point to the green turf drive cul-de-sac
Sample
for sole
elevations,
use
not
by
necessarily,
emergency first
what's
responders.
gonna be built here.
Number 5, all
custom
blasting
homes,
activities shall be in
anywhere
accordance
from,
with the
I believe,
Georgia Blasting
$550,000 to
Standards Act.
$750,000
Before blasting
allow
works
the,
begins, a blasting notification plan must be reviewed and approved by the Planning and Development Department. Said plan shall include signage, email notification, and any other
Outside of that,
notification
we
deemed
recommend
necessary.
approval for the LUP,
Number 6, uses
approval
involved
of the rezoning, and I'd
adult
just like to
entertainment.
read
This one's
the,
on all of them, so
conditions
you're worried.
as proposed into the
Including the
record, so
sale
we
or
have them.
display of adult
The
magazines,
property shall
books,
be
or
developed in
videos as
accordance with
defined by the
this conceptual
adult
site plan
entertainment and
entitled
effect on this
Master
date of
Plan
the
for
condition
Summit Chase West,
is
dated
imposed are
8/15/20
prohibited and signs higher than 15 feet and
2024,
larger than
revised
225 square
1/30/2025,
feet. Stamped
area
received January
are
31st,
prohibited.
2025, with modifications
Happy to answer
permitted
any
to
questions
meet
that the council
conditions
or
of
that the
zoning
planning
or
commission may
state,
have of
county,
them.
and city regulations. Substantial variation from the conceptual rezoning site plan as determined by the Director of Planning and Development will require mayor and council approval. Building setbacks are stated: front yard 40, rear yard 30, side and interior yards 10, and street side, basically corner 25, maximum
know,
lot
microphone.
coverage 45%. All driveways
I'll
shall be
start
a
over.
minimum
Will the
of 22
applicant,
feet in length.
thank you, come
measured from the
forward,
front of the
identify
garage
yourself and make your
to the edge of the
presentation.
sidewalk
Remember that you
closest to
have
the dwelling, and
15
shall be
minutes to
enough
work with.
accommodate the parallel
And also,
parking
please speak
of two
directly
vehicles.
into the microphone, as
Developer
I'm
is to,
obviously
number
still
4,
learning today.
developer to provide an emergency access.
Well, good evening,
gate
Mr. Chairman,
connection point
Planning
to the green
Commissioners. My
turf
name is
drive
Shane
cul-de-sac
Lanham with
for
Mahaffey
sole
Pickens
use
Tucker
by
here on behalf
emergency
of the
first
applicant
responders.
KJ Luxury Homes.
Number 5,
Mr.
all
Cameron
blasting
Jalali
activities
with
shall be
KJ
in
Luxury
accordance
Homes
with the
is
Georgia
here with
Blasting
us tonight.
Standards Act.
As
Before
Mr.
blasting
Thompson
works begins,
indicated,
the blasting
we are
notification
before
plan
you
must be
tonight
reviewed and
seeking a
approved by the
recommendation
Planning and
of approval
Development Department.
for a future
Said
land
plan
use
shall
map
include
amendment
signage, email
from parks,
notification,
recreation
and any other
to residential
notification
low
deemed
density,
necessary.
and a
Number 6, uses
rezoning from
involved,
RS 30
adult
to
entertainment.
RS
This one's on
5.
all of them, so
So
don't worry.
I'll
Including
move
the sale
quickly
or
through
display
the
of adult
location of the
magazines,
property. I
books, or
think we all
videos
know
as
where
defined
it
by the
is. It's
adult
back
entertainment
nine
and
of
effect
Summit
on this
Chase
date of the condition
Country Club.
is
That's a little
imposed are
glossy,
prohibited and
but
signs higher than 15
it's the
feet and
remaining
larger than
undeveloped,
225 square feet.
unredeveloped portion of that Summit Chase Country Club,
prohibited.
and is a
Happy to
former
answer
golf
any
course. I think
questions
as
that the council-
as we're all
that the
aware.
Planning Commission
So the
may have.
proposed rezoning. This is the latest version of the site plan. We've had some revisions to it throughout the course of this rezoning action, and we'll take a moment to just say that we appreciate the staff's patience and hard work, and the Planning Commission. I know this has been tabled a few times as we've been working on revisions to the plan
I know, microphone.
in response to comments we heard at a community
start
meeting
over.
and
Will the
through other
applicant,
correspondence
come
with,
forward, identify yourself and
neighborhood
make your
residents and
presentation.
stakeholders.
Remember that you have 15
so
minutes
as
to work
Mr.
with.
Thompson indicated, we
And
have
also
a
please
proposed
directly
total of
into the
150
microphone.
homes. That's a
Obviously
density
still
of
learning today.
1.57 units per
So,
acre.
good evening, Mr. Chairman,
The
Planning
single
Commissioners. My name is
entrance
Shane
now
Lanham with
single main
Mahaffey
entrance
Pickens
is now
Tucker here on
located
behalf
off
of
Classic
applicant
Drive.
KJ
Originally,
Luxury Homes.
we had it coming
Mr.
in off
Cameron
of Green
Jalali
Turf, but that was
with KJ
something
Luxury
that
Homes is
seemed to
here
be
with us
particularly
tonight.
offensive to
As
folks,
Mr.
especially on
Thompson,
Green Turf.
indicated,
And so
we are before
the
you
challenge
tonight
we
seeking
faced, and
a
this is sort of what
recommendation
took
of
us
approval
some
for
time
a
to
future
work
land use
through,
map amendment
is
from
providing
parks,
the entrance to
recreation
Classic
to
Drive
residential
required,
low density,
going over,
and
there's
a
some ponds over there, there's
rezoning from
stream
RS
buffers,
30
there's
to
topography.
RS
It just
5.
required some
So,
significant
I'll
sort
move
of
quickly through
engineering
the location
review
of the
by
property.
the
I think we all
engineer,
know where it
but
is.
we've gotten
It's
to the
back
point
nine,
where
Summit
we can
Chase
propose that.
Club.
We're
That's a
confident we
little
can
glossy,
accomplish that and
but
have
it's
redesigned
the,
our
remaining
our plans
undeveloped,
accordingly.
unredeveloped
As Mr.
portion of
Thompson
that
mentioned,
Summit
we
Chase
would
Country Club,
maintain an emergency-only
and
access
is
to
a
green
former
turf.
golf course, I think,
That
as-
would be
as
gated with
we're
a
all
Knox
aware.
box,
So the
which just,
proposed
for anyone
rezoning,
here
this
tonight
is
who's unfamiliar with
the
what that
latest
is,
version
that's
of the
a
site plan. We've
special
had some
keypad or
revisions
lock
to it
box
throughout
that
the
first
course
responders have,
of
a
this
master
rezoning
key or master
and we'll
code
take a moment to just
where
say,
they can
that we
unlock the
appreciate
gate if they
the
need to access the
staff's
property in the
patience and
event of
hard
an
work. The planning
emergency.
commission, I know this
And
has
that's
been
a that's a fire code thing. Just it's based on the number of units in the development. The codes and fire marshals like to see at a community meeting additional
and through
entrances
other
there.
correspondence
We've
with-
also
with,
provided a
neighborhood
35-foot
residents
wide
and
buffer
stakeholders.
around the perimeter
So
of development.
as
The
Mr.
intent
Thompson
would be
indicated, we have
to
a
leave that
proposed
undisturbed
total
where
of
we
150
can, but
homes. That's a
in
density
certain
of
cases where there's
1.57
topography
units
or
per
other
acre.
issues, we
The
would propose
single
to
entrance is now
have
single
limited
main
grading or
entrance
land
now
disturbance
located off
activities
of
there, but
Classic
then
Drive.
replanted
Originally,
to a
we had it
buffer
coming
standard
in
to
off
provide
of green
appropriate
turf, but that was something
separation
that,
between the proposed
seemed to be particularly offensive
development
to folks,
and
especially on green
surrounding
turf. And
uses.
so the challenge we faced, and
as
this is
was
sort of what
noted,
took us
RS5 is the
some time
zoning
to work through,
classification that we're
is
seeking,
providing the
but
entrance to
we're not,
Classic
I would
Drive
say,
required, going
using
over, there's some ponds
RS5
over
to
there,
its
there's
fullest
stream
extent.
buffers,
I
there's
think if you were to
topography,
design the
it just
subdivision under
requires some
RS5,
significant
which
sort of,
allows smaller
engineering
lots,
review
narrower
by
lot
the
widths,
engineer,
and even
but
smaller
we've gotten to the
homes,
point where we can
it would be a much different
propose that. We're
project.
confident we
But
can-
what
we
we
can
are
accomplish that
proposing
and have
is a minimum
redesigned
lot
our-
size of
our
10,000
plans
square
accordingly.
feet. RS5
As Mr.
allows a
Thompson
minimum of
mentioned, we would
5,000.
maintain an
We're
emergency
proposing a
only
minimum
access
lot
to
width
green
of
turf.
65 feet.
That would be gated
The code
with a
allows a
Knox
minimum
box,
lot
which
width
just
of 50
for anyone
feet.
here tonight who's
And also the
with
code
what that is, that's a
allows
special
a minimum
keypad or
1,000
lockbox
square
that first
foot
responders have
floor
a
area for
master
homes,
key
and
or
we've
master
proposed,
code
at
where
least for the
they
two-story
can,
homes,
unlock
2,400
the
square
gate if they
feet.
need
There's
to
been some
access the property
discussion
in the
about,
event of an
maybe
emergency.
having a
And that's a
2,200
that's a
square
fire
foot
code
for
thing,
some
just
ranch
it's
plans,
based on the
but
number
the
of units in
main
the development,
typical
the
two-story
codes
residence
and
would be a
fire marshals
2,400
like to
square
see,
foot
additional
minimum.
entrances there.
The homes here,
we've
there's
also
provided a
provided
35-foot wide
sizes and
buffer,
home
home
width,
width,
so
so with that
development, the
larger,
intent would be
wider
to
lot
leave
width,
that undisturbed
there's an
where we
opportunity to have a
can, but,
variety of
house
in certain
plans,
cases where there's
depending on the dimensions
of
of
the specific lots,
so we're
have
excited
limited
about the
grading or
ability
land
to
disturbance
provide,
activities,
variety
there, of home styles within
buffer
the
standard to
community.
provide appropriate
And
separation between the proposed
would submit to the
development
planning
and-
commission
and
that the proposed
surrounding
development
uses.
is an
So,
appropriate land use
as
for the
was
property,
noted,
given
RS5
the
is the zoning
character and
classification
nature
that
of
we're
surrounding
seeking,
development
but
and the
we're not,
policies
I would
of
say,
Snellville's comprehensive plan.
using
So,
RS5 to its
I
fullest
think
extent.
everyone
I
is
think if you were to
is
design
mostly
the
familiar with the
subdivision
history,
under
but this is
RS5,
essentially
which allows
golf
smaller
course. You know,
lots,
it
narrower
was healthy
lot
when it was
widths,
healthy and when it
even
was not, it
smaller
was
homes.
not. And so despite the best
It would
efforts
be a
of the
much
property
different
owner to keep
project,
that
but what we are
operation
proposing
going,
is a minimum
just
lot
times
size of
change, things
10,000
change,
square
and
feet.
we would submit to the
RS5
planning
allows a
commission
minimum
that
of
a
5,000.
golf course on the property
We're
is no
proposing
longer
a minimum
viable
lot
use.
width of
So
65 feet.
what we do is we
The
say,
code
well,
allows a
what
minimum
does the
lot
property
width
owner
of
do with their
50
property? Well,
feet.
they
And also
in
the
the
code,
development world, what they do is they look
allows
to
a
the future
minimum
land use map
1,000
to
square
see,
foot,
what would
floor
the
area
comprehensive
for homes,
plan
and we've
indicate as an
proposed,
appropriate
at
land
least
use.
for the
And so
two-story
here,
homes, 2,400
the
square
property
feet.
was
There's been some
designated as
discussion
parks
about,
recreation.
maybe
That's an
having a
extremely limited land
2,200
use
square foot
category,
for
which
some
is
ranch
really only
plans, but
reserved
main
for public
typical
parks.
two-story residence would
The
be a
other areas that are
2,400 square
depicted
foot,
as parks recreation
minimum. Or like
the
Briscoe
homes here,
Park,
there's
South
a
Gwinnett
variety of
Park,
options,
Oak
plan
Road
sizes,
Park.
and
It's
home
really
widths.
municipal
So with
or
that
government
larger,
parks that bear that
wider
designation. I think
lot
the
width,
golf course had
there's
it
an opportunity
just
to
because
have
that's
a
golf
golf course. That was a
house plans,
recreation type use.
depending on
but
the
the
dimensions
surrounding
of the
area, the
specific
property is
lot. So we're
surrounded by
excited
residential
about the ability
low
to
density.
provide,
And
a
so
variety
when the
of
property owner's
home
looking at
styles
their property and
within
saying,
the community.
the golf course use is no
And
longer
so,
viable, I need to change use here, I think you
would
look
submit
around
to
and you
the
say,
planning
well,
commission that
what
the
is
proposed
everything else that
development
surrounds
is an
us
appropriate
designated
land
as
use
on the future
for the
land use
property,
map? And that's low density
given the
residential. So that's what we've
character,
proposed in our
and
land use
nature
map
of surrounding
amendment
development
tonight.
policies of Snellville's
That future
comprehensive
land
plan.
use map
So,
designation of residential
I think
low
everyone
density
is
accommodates,
mostly familiar
and here's
with
just
history,
a,
but this
a
is
map
a
to
essentially
show,
a failed golf
kind of the
course. It
oddly
was
shaped,
healthy when it was
green,
healthy and when it was not,
area
it was
there
not.
surrounded
And so despite
by
the best efforts of the
residential low
property owner to
density.
keep that
So
operation
the description of that
going,
future land use
just
category in
times
the
change,
comprehensive
things
plan
change,
is
and,
single-family
we would submit
residential
to the
areas
planning
less than
commission
4
that
units
a
per
golf
acre.
course on the property
We're
is
less
no
than
longer
half of
viable
that at
use.
1.57
what we do
units
is we
per
say,
acre.
well,
So
you
I'd
know, what
submit to the planning commission that the proposed development
in the development world,
under
what they do is they look
RS5,
to the future
but
land use
it's
map
not just
to see,
RS5. We've
what
tried to
would the
tailor it to
comprehensive
fit
plan
the property
indicate
to
is an
be
appropriate
sensitive
land
to
use.
the
And so
character of
here,
the surrounding area.
the property was
We're aware
designated
that
as
this
Parks
is an
and
established
Recreation.
area and there's some
That's an
older,
extremely
larger
limited
lots.
land use
So what
category,
we've tried to
which
do
is
is
really
strike a
only
balance
reserved for
between
public
what the
parks.
comp plan would
The
theoretically
the other
accommodate
areas that are
if one were to
depicted
try to
as Parks
maximize
Recreation,
density, minimize
Briscoe Park,
lot
South
area,
Gwinnett Park,
but try
Oak
to
Grove
also
Park.
have a
It's really municipal or
a
government
project
parks that bear that
can
designation. I think
support
the golf
a
course
real
had
estate
it
transaction
just
and
because
is
that's
something that
golf course. That was a
would fit with
recreation
the type
policies for
use.
comprehensive
But
plan.
the
So
surrounding surrounding area. At 1.57 units per acre, residential, we are less than half of that. The property owners looking at their property and saying, in the future land use category is no longer viable of the comprehensive change use here. I think you would also submit that proposed development everything else certainly compatible with surrounding residential uses. You know, buffers in this case aren't required, and we've provided a 35-foot wide buffer in between the proposed development surrounding uses, but we're also adjacent to that Soleil development that was touched on in staff's presentation. So that's, while age-restricted, I believe it's 55 plus, it has a mixture of what I understand to be 50 and 60-foot wide lots. So smaller lots than what we're description of that future land use and at a density of 3.4 single-family residential areas less. So again, more than double the density that we're proposing at 1.57 units per acre. That Soleil is, I believe it's 257 units, approximately 75 acres. Under RS5, would submit to the Planning Commission that that's an appropriate land use for the property, given the policies of the comprehensive plan of the surrounding area of surrounding development. We're aware that this is an established area and there's some pause here, conclude my presentation. I'm happy to answer any questions that y'all may have, theoretically, but would like to reserve the balance of my time. If one were to try to maximize density, minimize lot area, but try to also have a
Mr. Lanham, you have 6 minutes and 11 seconds left.
Real estate transaction, and is something that would fit with the policies of the comprehensive plan. So at 1.57 units per acre.
Fine, thank you.
We are less than half of that 4
Good
units
evening,
an
sir.
acre
How are you?
that's described in the future land
I have
use
a question
category
for you.
descriptions
Yes, sir.
of the
So
comprehensive
my
plan.
question is
Would also
regarding to the
submit
land
that the
use
proposed
plan.
development
And-
is certainly compatible with surrounding residential uses. You know, buffers in this
We have
case aren't
some-
required.
well,
We
my question
provided
is
a
actually
35-foot
about
wide
lots
buffer
1 through 5
in
and
between the
106
proposed development surrounding
through
uses, but
133,
we're also adjacent to
and the
that
covenant
Soleil
with the-
development that was touched on
the
in
covenant
staff's
with the Summit
presentation.
Chase
So
Homes
that's,
Association.
while age restricted, I believe it's
Has that-
55 plus.
has that been
it has a mixture of what I
resolved
understand
yet?
to be 50.
So we
and 60
are aware
lots. So smaller
that
lots
I think
than
it
what we're
was
proposing.
30, maybe
And at a
40
density of
something
3
plus
plus
years
years
ago,
ago,
there was
so
a
again,
covenant or something in the covenants for
density that we're
the Summit
proposing
Chase
at
community
1.57
regarding the use of those lots.
Soleil is,
Just to be
I believe
candid,
it's 257
we don't
units
believe
on
our legal
approximately
position that
75
that is
acres.
not
So,
a valid and
would submit to the
enforceable
Planning Commission
covenant
that's an
that would
appropriate
restrict the
land
use and
use for the
development of the property.
given the policies of the
And so
comprehensive
that's
plan
why
and the
we've
character of
utilized
surrounding development.
that portion of the property for
I'll
lots. You know,
pause
originally,
here,
the
conclude my
site
presentation.
plan
I'm happy to
didn't
answer any
depict
questions
development
that y'all
in
may
that
have,
area.
but would
And
like
and
to
candidly,
reserve
what
the
kind of
balance of
spurred
my
it on was we identified that issue and we said, let's stay away from it. At the community meeting,
I'd like to say, Mr.
it seemed to
Lanham,
be,
you have 6
and
minutes
these
and
weren't
11
the only
seconds
concerns, but
left
it seemed that some of the primary concerns were, we want access off of green turf, and we want you to pull lots away from the established subdivision.
Good evening, sir. How
So
are
we
you?
looked at it and we said,
I have a
one
question
way
for
we
you.
could do that is to utilize
So
that
my
central
question is
area where
regarding to
those
the land use
covenants
plan. And-
were identified. And so by utilizing that area, what we were able
We
to
have
do was
some-
pull lots
well, my
away,
question
Trace,
is
pull
actually
lots
about
away
lots 1
from
through 5
Beaver
and
Creek
106
Lane, I think it is,
133,
and provide the buffer. So
and
we
the
were able to
covenant with
pull the
the-
lots to the inside of the development,
covenant
put
with
the
the
buffer
Summit
around the
Chase Homes
perimeter.
Association.
And through study and
Has that-
consultation
has that
with
been
real estate counsel.
resolved
So
yet?
just, so we are aware,
My capacity,
that
I think
in
it
representing
was
KJ
30,
Luxury
maybe
Homes is
40
relative to the
something
land use. I've been
plus
hired to do the
years
land use.
ago.
I haven't
There
been hired to
was
do the real estate
a
transaction.
covenant or
which
something in the covenants
in these
for
real
the
estate
Summit Chase
transactions,
community
there are pages regarding the
pages
use of
and
those
pages.
lots,
Just
title
to be candid,
exceptions,
we don't
covenants,
believe
and
our
all
legal
sorts
position
of
that
real
that is
estate
not
legal
a
issues
valid and enforceable
that have
covenant
to be
that
worked
would restrict
through,
the use and
as
development
part of
of the
that
property.
transaction. But in
And
consultation
so
with real estate
that's why
counsel,
we've
we believe that
utilized
those
that portion of
those
the property
covenants
for
are
lots,
not
valid and
originally
ultimately not
the site
enforceable,
plan, and we
didn't
felt confident enough
depict
in
development
that
in
to
that area.
spend and candidly, what kind of spurred it on is
civil
we identified that
engineering,
issue and we said, let's stay
work
work
and
and energy
at the
to
community
redesign
meeting.
the site plan.
It seemed to be,
relocate
and
the access off of
the only
green turf,
concerns,
and
but
to
it
provide
seemed
that
some of
buffer in the
the
redesign. primary concerns were, we want
Okay,
access
so I'm not
off
an
of green
attorney,
turf,
so
and
I'll
we
just ask
want
this the way
you to
that I
pull
think that I would.
lots away
So
from the
you don't
established subdivision. And so we looked at it and we
you
said,
don't have a
one
legal
way we could
stance.
do that is to
Your
utilize that
assumption is
central
that
area
they're not
where
going to hold
those
up.
covenants. Ultimately, we think that those are
not
identified,
enforceable
and so by
covenants that would
utilizing
restrict
that
the use
area,
of
what
the
we were able to do was pull lots away.
So in the application, there's a question as to why developing under the current zoning RS30, and I'll even expand on that, even drop it down to RS15, would not be economically suitable. Can you expound on that?
Yeah, so we, in the application, those standards governing the exercise of the zoning power, that question, does the property have a reasonable economic use as currently zoned? We submit that it doesn't. We think that the proposed development represents the reasonable use of the property based on, a variety of factors and physical conditions of the property, including its size, its shape, topography, physical characteristics, subterranean, to use a $10 word, just say there's rock out there. And so what we are trying to do there is we would say under the current future land use map designation, which wouldn't even encourage RS30. We would say that RS30 does not provide the owner a reasonable use of that land, given the policies of the comprehensive plan, and also given, quite frankly and candidly, some adjacent development which provides a land use which is double the density and smaller lots.
Can you point to the existing lot number 5 off of Garmin Drive cul-de-sac? It's in the bottom left of their development. I can't see, it looks like it might be what you're proposing, lot numbers 90 through 100, but they're so small it's hard to read. Do you see that it's an oddly shaped?
I thought you were talking about our lot 5, which is over there. But
Yep, that's the one.
Yep.
So just to be clear, I don't own property in Summit Chase. The only dog I have in this fight is sitting on this council. But I did a little Googling, and that is $1 million home on Zillow. And you're going to put 14 houses behind him. Where does that fit into the character of the existing homes, which is what we expect out of the future land use plan? How do you make me see how that's reasonable?
Yeah, so I think what we try to do there is, even though price point is not per se a land use question, I think it's part of the discussion. It always is. And so I think what you have to ask is, when you're looking at an applicant and a property owner, are you only allowed a zoning which matches the most expensive house in the area, or would it be appropriate to have a zoning classification and a development which is reasonable in the larger context, right? And so, there's that word, it's in a lot of these planning documents, it's compatible, right? Is the proposed development compatible with adjacent and surrounding development? Not necessarily consistent or identical, but is it compatible? And so I will grant you, I mean, I've driven the area as part of my representation here, and it's a beautiful area, and those are beautiful homes. It is somewhat oddly configured, and it sticks out kind of on a point. And that lot was sort of always at the mercy of, is not the right characterization, but the use of that adjacent land is sort of always a factor on how desirable that lot is. And when it's a golf course, when the property owner just wants to use their land as a golf course, then I think a lot of people would find that desirable. But and less people may find it desirable if it were to be developed for residential use. But we also have to.
If you lived in Lot 5, would you find it desirable if there were 14 tiny homes put behind you?
I wouldn't buy a lot that was surrounded by undeveloped land that stuck out like that, knowing that it's always possible that my neighbor who owns their property could use it for something else that I don't control. But that's personal. But sure. The bigger point I did want to make to your question, because it's a fair point, is that larger context. Just looking on it, sort of a non-scientific approach. But I've found over the years that the sold homes through internet research, and Zillow particularly, is good at identifying, and they base it on public deed records data, sales price. The square footage, I'm not trying to disparage real estate agents, but the square footage is sort of, what do we feel like it is? And that's not accurate, that's unfair. But the sales price and the sale date I've found to be reliable. And so zooming out, I see a range of mid 300s, upper 300s, and this is just sales in the last 12 months. High 300s to mid 400s seem to be sort of the most common sales range in that area. Now, of course, there are homes in the 600s and the 700s, absolutely. And so I think what we are trying to do here, and I think this is in line with the spirit and intent of the comp plan, is to, again, provide a development that's compatible given that whole broad context. And, you know, we're not trying to tell anybody these are all going to be $1 million homes. We do anticipate that they are going to be higher than 300s, higher than 400s. I think we project them starting in the fives.
Okay, moving on. We are in receipt of your letter from Julia Maxwell, who I assume is one of your partners at Mahaffey, Pickens, Tucker, dated October 10th, 2024, the justification for rezoning. I am also not a lawyer, but I've spent a couple years in a classroom, and so I know to pay attention when people say I'm going to violate their due process from the United States Constitution and or the Constitution of the State of Georgia of 1983. I'd like to focus on a paragraph in that letter that states that the property is presently suitable for development under the RS5 classification and would not be economically suitable for development under the present mixed RS30 zoning, which we've talked about. A denial of this application would constitute an arbitrary and capricious act by the City of Snellville City Council without any rational basis, therefore constituting an abuse of the discretion in violation of Article 1, Section 1, Paragraph 1, blah, blah, blah. I won't get into the codes. How then did the Supreme Court of Georgia and DeKalb v. Dobson come to their finding if you're saying that denying your rezoning would violate the Constitution? Are you familiar with that finding, that case?
Yes, sir.
Okay.
Vaguely.
Okay, well, let me read what they stated. A significant detriment to the landowner is not shown by the fact that the property would be more valuable if rezoned, or if by fact it would be more difficult to develop the property as zoned than if rezoned. So we would not be violating your rights if we refuse to rezone this as RZ5 according to the Georgia Constitution in DeKalb v. Dobson. I'd also like to go to another case, Gwinnett County v. Davis, that states that evidence only that it would be difficult to develop the property under its existing zoning or that the owner will suffer an economic loss unless the property is rezoned is not sufficient to support the legal conclusion that the owner suffers a significant detriment. I just find it frustrating as a non-lawyer, but as a physician who spent time in a classroom, to be told that I'm going to violate your rights as a developer if I don't give you your classification that you want. It's threatening, and it's really ticked me off. Honestly, I've lost some sleep over that letter.
Okay.
Over the months that you've capriciously denied us going through this process. Nothing about this has been capricious or arbitrary, except for the developer repeatedly asking for us to postpone these meetings. And this has been on our case since October, and it just frustrates me. And frankly, I just want to take the opportunity to object to the verbiage that you've put on us as not paying any attention to this or just being flippant about what's going on.
Commissioner, that is absolutely not what's happening. And I am sorry. I'll explain it.
Do you want to retract the letter?
No, sir. No, sir. Here's what's going on with that letter. Every rezoning application that a law firm files is going to have that letter. I'll let you consult with the city attorney to say if what I'm saying is true. I believe it is my professional responsibility to submit a constitutional objections letter with every rezoning that I do. That's our firm's policy since before I started even practicing law. And many in the legal profession would regard it as malpractice to not submit a constitutional objections letter, because if it's been long held that if a property owner or an applicant wanted to appeal a zoning, they may not avail themselves of any of those constitutional arguments in superior court if they didn't raise them below. So if a property owner were to try to go to court and say, look, and I'm not saying this is our case, I'm just saying in general, my constitutional rights were violated, the regulations of the local government have removed all economic use of my property through denial of a rezoning. If they didn't submit a constitutional objections letter to the city, they don't get to raise those arguments in court. And so I apologize if that caused any consternation. I really do. And if I was sort of making faces and gesturing, it wasn't to try to cut you off. It was just because there really is a valid explanation for that letter.
But that the state of Georgia has held in two different case laws. Whenever I Google case law and the Georgia Constitution as far as due process, Those are the cases that come up over and over again on lawyer blogs that practice real estate and land use law in the state of Georgia. If you hadn't sent the letter, I wouldn't have even bothered to Google it. So now it's led me down this pathway of, well, they really don't have an argument because the Georgia Constitution is held up in cases in Gwinnett County and in DeKalb, our neighboring county, that really we don't violate your rights by not giving you the rezoning you're requesting, because it probably could be developed under RS 15 or RS 30 classification.
So I would just say that an owner may not be entitled to the highest and best use of their property. On the complete opposite end of the spectrum, zoning ordinances are generally valid, right? And so the contests come in that middle ground. And the argument in a zoning, when a property owner or an applicant sues when their zoning gets denied, what they're saying is essentially it's an inverse condemnation. It's a regulatory taking, because through your zoning ordinance or other operations of city law or city actions, you've deprived me of enough use of my property that I'm entitled to just compensation. And so the case law in those cases, in Dobbs in particular, I think it talks about the property owner is not necessarily entitled to a zoning classification which would accommodate the highest sales price. It's all about a reasonable use of land. And so I think that's where the arguments occur. That's where, when zoning appeals do go to litigation, which is pretty rare, that's typically the battleground.
And then due process clause of the 14th Amendment of the United States Constitution. I mean, you go tossing those things around, people are going to pay attention to you, right? So the due process clause was enacted after the Civil War to address slavery and the rights of man as being all equal to the process of the law. We've only, in the last few decades, applied it to real estate law. Again, I'm not a lawyer, but having done some digging, due process is what we're doing right now. So to say that we're violating your due process, this meeting, me spending my time away from my family to listen to this, is part of your due process. You're not being violated. You're not losing due process under the 14th Amendment. So don't go throwing those things around. I get that maybe that's how lawyers work, but it kind of just, it just rubs me the wrong way. Maybe it's because I'm a doctor and doctors don't get along with lawyers. We just don't, like that's just kind of, we don't really meld. But it just doesn't feel good to be told you're going to violate your rights if I say, no, this shouldn't go forward.
I apologize.
Do I understand you correctly to have suggested that the letter that he's referring to is more like a safety valve for you?
That's right. It's a letter that preserves an applicant or property owner's rights to bring up constitutional arguments at trial. And we have to submit it. I don't know that the city is going to give us due process. I know that we're in it right now, but I need to raise those objections while the case is ongoing, because when city council hits that gavel, if they do something that does violate due process that I didn't know was coming, I can't say time out, here's my constitutional objections letter. It's too late. And so I would submit to you, for what it's worth, the standard practice among zoning attorneys in Georgia is to submit those cases with their application initially. Now, what we do sometimes is, in jurisdictions where we haven't handled many cases, and it's, I think our firm, maybe it's been a year or so, we worked on a rezoning case not too far away a couple of years ago on the nearby property. Sometimes what we'll do is submit those later with a cover letter that just says, these are not fighting words, they sound like it. This is an obligation we feel as a professional responsibility to raise these constitutional objections now for legal reasons.
Might be a good idea next time.
Yeah, I think. Yes, sir.
Mr. Chairman, if I could add some input on this. Yes, sir. While the letters are generally threatening and all of that, it is a form letter that Mr. Lanham has to submit to protect his client's rights, and we would do the same thing. I would do the same thing if I was in his position, and so he is just protecting his rights. He's not asserting or putting any allegations towards this board or the city council. It's just a form letter to protect his client's rights. So that's what I would say about that.
Thank you. trying to decide if I want to say something. It's not easy. It's tough. You referred to a nearby development, but is that development something that dropped out of the sky and has surrounded all these other houses?
So I think
You follow my question.
I'm sorry?
You follow my question.
Maybe. Now, lots of things go over my head, so please forgive me. In the conversation with Commissioner Kissel, I referred to a zoning we worked on a couple years ago. That was the Tomco facility. The other development I referred to in my main presentation was that I think it's called Soleil right now, which is that, I think, RHOP 55 or that age-restricted community.
My question then is was that community developed on all bare land, or did it fall out of the sky and surround all these other homes?
So my understanding is that was developed
from the ground up?
It's starting now. It was the front nine, I guess, of the golf course.
Okay. I see, and I'm bringing that up because I see an extraordinary difference between what I see here as a surrounding of long-established, and I'm the first guy who wants to support owners' rights and that kind of thing. But I see this as being, I don't know, I have issues with the compatibility factor that you have mentioned several times. I don't see how the homes that you've shown us have any compatibility with the homes that are built, established, developed, et cetera, et cetera. So I just wanted to raise that question. Thank you.
Yes, sir. I'd be happy to respond to it, or if that was okay. Yes, sir. So I think there, these land use plans, these comprehensive plans, it's that compatibility, right? And beauty's in the eye of the beholder. Compatibility's in the eye of the beholder too, I think as well. And some people who are in a single family detached home on a 65, 75 foot lot may feel like it is incompatible to have townhomes next to them or to have commercial next to them. And some people may disagree with that, and they think that it is. And so what we tried to do to be sensitive to that, and perhaps we didn't go far enough. I mean, that's a fair point for anyone to make. But a 10,000 square foot, so roughly quarter acre lot, they're not as big as some of the estate lots off green turf or to our south. But 10,000 square foot lot, 65 feet wide. I think one could say that with a 35-foot buffer, that is compatible. That's a decent enough separation between a larger lot and a smaller lot that makes it, generally reasonable. I think someone could make that argument to say that maybe without a buffer, it'd be a different question. With a buffer, I think that's another one to provide there. But it's that range of compatibility, and I think that differs between people.
I appreciate the buffer, and that what my concern is a little different, which is to say that, again, I see a much smaller number of homes being surrounded. And for me, that's not necessarily compatible. So I'm trying to have you help me figure out compatibility? And we're looking at compatibility. It's one thing if I live somewhere and then adjacent or nearby or something, townhomes get built, and I may not like it. But this is a very different in that this is sort of like a home invasion in that you're coming in and dominating and redefining and reestablishing what is going on this land and what's around it.
And so I think the other way you could look at it is to trace it through the comp plan. And I think the dots to connect would be the golf course has failed. We need another use. Residential use is really the only other option. I think a lot of people might think that's the case. And so let's consult the comprehensive plan. What is everything that surrounds us designated as residential low density? All right, let's consult the policies of residential low density. What does it accommodate? RS5, RS15, RS30. okay, well, let's dig into those zoning classifications and see which one we feel like suits the property best, which one we think can provide enough flexibility in the development and construction to accomplish some things, including, you know, moving the access to Classic Drive and doing buffers and things like that. And just looking at the fact that RS5 is deemed an appropriate zoning classification in residential low density, and we exceed a few significant dimensional standards, specifically lot size, which we double, minimum lot width, with which we exceed by 15 feet, and the home size. And so I think that the comprehensive plan policies also speak to what's compatible. And I would say that the RS5, as specifically as presented, aligns with the policies of the comp plan.
I'm going to suggest that the comprehensive plan probably did not foresee the nature of this type of project, which was to come into an arena and surround everything. I don't disagree with you about what you're saying about the comp plan or anything like that. Mm-hmm. The application here is very, very different because there are long established homes, lot sizes, everything like that. And this is, to me, this looks more, and I'm being very careful in how I state it because I remain open-minded and all that kind of stuff. But this is a very different thing when you're just coming in and taking and utilizing land, and I'm in support of landowners, obviously. You're utilizing land that is mixed in and miscegenated with all these other land. So falling back on the comp plan and what the comp plan may or may not allow, to me, is a little bit different discussion than what this actually represents. I'm actually appreciate that you've not gone to the minimum lot size. Good for you for that. I still don't know that I think it makes everything compatible, but that's just something I'll have to contend with. But thank you so much.
Yes, understood.
Anybody else? And so you still have 6 minutes, 11 seconds. Thank you.
We will now open the floor to public comment. Is there anyone who wishes to speak in support of the request before us? Please come forward and state your name and address, keeping in mind the time limitations. There's 15 minutes for all public comments. Would anybody like to come forward? That was fast. Is there anyone who now wishes to speak in opposition to the request before us? Please come forward, state your name and address, keeping in mind the time allotment. We would like your name and your address, please,
Yes.
when you get to it.
I'm also timing myself to try to see how close I am because I'm speaking for everyone, so
Okay.
I'm gonna do that. Good evening. And thank you for being here for us and for listening to our opposition and being as open-minded as you said. My name is Christina Vincic. I go by Kit, and I live at 1410 Summit Chase. This is Megan Pallet. She also lives in Summit Chase, and she's going to be helping me with the overhead. When I first visited Snellville, I left saying this place reminds me like my hometown. And my husband always dreamed of living on a lake, so he was really excited to have a prospect of a community where we could, you know, live by a lake and have awesome neighbors. So Snellville became home about 2.5 years ago to us, and we're 2.5 years Snellville young, but we love Snellville all those years. And we know how important it is to share our city with other people to sustain it. And so when anybody comes and visits, we're always bringing visitors to the farmers market and restaurants, stores, and Saltville Grotto, and, you know, all those places. So I'm really appreciative to the people who created a way for these amazing experiences and all of the people that surround us in our just completely unique neighborhood where everybody comes and says you live in an oasis. And so it's nice to meet you all. Tonight I speak on behalf of everyone who's behind me as the spokesperson of the Snellville residents and homeowners of Summit Chase, Timberline Trace, Misty Fairways, Misty River Estates, Alta Ridge Way, South Winds, and Steeplechase. Those neighborhoods include approximately 648 homes, and together we oppose the application by KJ Luxury Homes to rezone the Summit Chase Country Club property owned by Summit Chase Country Club, Inc. from RS30 to RS5, referred to as the Summit Chase Green Zone Rezone. Several members of our community have collaborated on this report that I believe you might have received last week, which I'm going to be talking about. And we hope that it provides overwhelming evidence to stakeholders, you all, and the city as to why this application should be denied. Although the builder is only required to submit a conceptual site plan, it lacks basic details the city requests for a substantial project like this. And it is crucial to note that was something that was brought up earlier, which are the covenants, which we have here, that it seems to be contingent on the dissolution of this 40-year legally binding covenant with Summit Chase Homes Association, for which development on lots 1 through 5 and 106 through 133 are not permitted. Summit Chase HOA has not agreed to release this covenant at this time. And to our knowledge, these two lots totaling 10.7 acres were purchased separately from the golf course and at a later date. According to the legally binding steeplechase section of the Summit Chase Declaration of Covenants, they may not be re-subdivided. We do not see required proof of the deeds for lots 55 and 56 of Block D, land lot 93 in the application, or mentioned in the planning director's case analysis. The builder's letter of intent does not provide data to support its claims, does not conform to the newly crafted 2045 comprehensive plan, nor the Summit Chase character area. And it does not accurately describe its intentions. For example, the builder claims, and it was reiterated in the analysis, that it will create a gross density of 1.57 lots per acre, creating the appearance of spacious lots. But this figure includes all of the large non-buildable parts of this land. When we subtract those areas in the calculations, we are left with roughly 3.6 lots per acre. Thus, the builder's implication that it generously exceeds the city's maximum allowance of 3.9 is misleading. And this proposed rezoning would crowd rather than reinvigorate our neighborhood. So here you will see on the application, attachment A with the builder's response from RZ 2404 retyped into the form verbatim. Their answers for L402 were mostly copied and pasted from the application. Importantly, this attachment warns the application that their answers must be an analysis and not simple yes or no restatement of the questions. That's not acceptable and shall be considered non-responsive. The yellow highlighting illustrates how the builder has restated the city's questions. The pink highlighting indicates false or oversimplified answers that lack the analysis the city requires. Thus, the city should consider only the two clauses left unhighlighted and deny the application for failure to provide the required information. Each of the builder's responses are explained below. Please note that this application has been signed by Cameron Jalali and his attorney to swear and affirm under penalty of perjury that statements and documents submitted are true and accurate to the best of their knowledge. A, the builder states the existing homes and proposed homes would be both single-family and detached. The reality is that the proposed rezoning is drastic. It skips over RS-15 entirely and does not complement the character area of the surrounding communities. RS-5 is newly established and unwarranted here given the adjoining estate residential properties and the fact that it is miles from the town center. According to the UDO 202-41 through I'm not a lawyer. The UDO 202-4.1, RS5 purpose. The district is intended to provide areas for high-quality, small lot, single-family detached housing in a walkable setting. Summit Chase is not a walkable setting. Compact, walkable communities have their merits, but they are not appropriate in an area surrounded by established estate-sized homes. B, the builder says that the zoning proposal wouldn't impact surrounding homes. That's wrong. We know this for certain because we have already felt the harmful impacts of the development of Soleil. We chose to invest in our homes because of the nearby amenities, lot sizes, safe, quiet streets, and natural features. All of that would come to an end as we would have tightly spaced tract homes in the middle of our community. Classic Drive residences would be especially impacted by increased traffic from the main ingress and egress for 150 new residents and their deliveries. It will be less safe to drive, walk, and live on. C, the builder writes that due to its size, location, and layout, the land does not have reasonable economic use as currently zoned. But the long history of the country club shows that the parcel does have potential for economic uses as currently zoned, and if it were fully utilized. Additionally, the landowner has stated in public that there have been previous parties interested in purchasing the land to develop it at RS30, proving the drastic RS5 rezoning is not necessary to the viable use of this land. D, both the builder and planning director said the proposed development is less than 1 mile from Athens Highway. However, potential residents would have to drive through their streets plus about 1.5 miles from the egress at Classic Drive through our neighborhoods to reach Athens Highway. This neighborhood within a neighborhood will cause our streets to become a thoroughfare. The builder touts the number of rounds of golf that were played each year at the country club, but occasional visits to the golf course pose far less impact on the community than recurring frequent traffic of residents, their visitors, school buses, repair and landscaping persons, sanitation, and the various sources of mail and package delivery. Additional concerns about the density of the site include increased traffic on already congested roads, tie-in and damage to aging sewer lines, timely access by emergency services, and impact underperforming schools like McGill Elementary, Grace Snell Middle, and South Gwinnett High. These topics were not addressed in the analysis. E, the builder states that rezoning the proposal will be in line with the spirit and intent of the low-density residential future land use character area upon application approval. Here, the applicant avoids answering the question. As you can see, the future land use map, this site is one of only 3 large parcels zoned as recreational in the entire city. As Mr. Thompson pointed out in his report, some of the key strategies for Summit Chase area include A, exploring opportunities to construct a multi-use trail along Big Haynes Creek, B, preserving green space and wooded areas, C, protecting the Big Haynes Creek watershed, and D, reinforcing neighborhood stability by encouraging more homeownership, meaning versus rentership, and maintain or upgrade existing properties. How will this proposed development support any of these strategies? We only see contraindications. Focusing on the word reinvigorated and omitting everything else outlined in the character area is not a truthful expression. The builder and planning developer have glossed over items A through C. Additionally, the comprehensive plan outlines goals such as create a space for people to meet and gather within neighborhoods. Identify and acquire parcels for additional future parks and green space. Improve access to parks and green space from neighborhoods. Continue to protect water quality in the Big Haynes Creek watershed. Enhance existing neighborhoods with convenient access to sidewalks, greenways, and parks. Invest in infrastructure.
5 minutes remaining, ma'am.
Thank you. Invest in infrastructure that creates more walkable neighborhoods. The proposed rezoning accomplishes none of these goals and instead undermines them. Therefore, the builder's proposed development does not align with the policy and intent of the future land use map nor the 2045 comprehensive plan. Rather, the builder is seeking to amend these carefully crafted documents to suit its purpose. The builder didn't finish writing their last sentence, and this question requires a complete answer. F, the builder lists no existing or changing conditions affecting the use and redevelopment of the property that would justify their request for rezoning. This raises questions about whether their motivation was purely financial. Instead of answering the question here, the builder references this area of the comprehensive plan out of context, claiming the development will meet the city's need for housing diversity, but it left out near town center. The builder told us that the proposed low-density detached single-family housing will be listed in the $500,000 to $600,000 range, which does not add affordable or diverse housing stock to Snellville. Furthermore, none of the diversity goals outlined by Section H-3 of the comprehensive plan apply to this proposed development. Therefore, they fail to answer the question and and their supporting grounds are not accurate. And I just want to mention the strategy to enhance Snellville's residential neighborhoods while diversifying housing options near near town center. Spacious single-family residences are a big reason families come to call this city home. The city will support the beloved neighborhoods through active code enforcement and infrastructure improvements like sidewalks and sewer. Expanding housing opportunities for young professionals will support a multi-generational community with suitable housing focused on the town center area. Now, the homeowners around, they've voiced some concerns to weigh against the rezoning. Because I'm running short on time, I'm going to bullet point them, but I believe that you'll be able to see them here. We have serious concerns with this development that go above and beyond just complaints and inconveniences. We have met multiple times to compile our concerns to express to you in these categories. Devaluation of existing properties and reduced quality of life for current residents. The builder stated that construction would begin in 2 years and last up to 10, depending on the market. This will negatively impact the market value of existing golf course estates and hinder their ability to sell. Would you purchase a home that had a decade's worth of construction set before it? And due to the Soleil land development, we have been experiencing earthquake-like tremors, sometimes on a daily basis, sounds of explosions and noise from heavy machinery and blasting for months. This shows an immediate and direct reduction in the quality of life. The necessary and this is part 2, the necessary extensive blasting will damage existing homes. Sizable areas of exposed granite, like you see here, exist on this property, and that is just a sampling. On October 30th, 2024, the builder admitted that he would have to blast to build basements and provide utilities, and that he had not blasted before. Neighbors have already reported damage to their homes from blasting attributed to Soleil. And this is not hypothetical. It is highly likely to occur again. It will create additional problems such as dumping rubble, releasing radon into homes and waterways, and cracked septic tanks and swimming pools in Southwind Estates. We are unprotected from harm, and we have truly no recourse. The development will exacerbate already congested traffic. Incomplete sidewalks and non-existent traffic lights for existing neighborhood exits on Rosebud create dangers for pedestrians. The proposed houses do not complement the character of I'm sorry?
1 minute remaining.
Thank you. Surrounding neighborhoods. Construction and deforestation will cause water pollution, erosion, and silt accumulation in the nearby creeks and lakes. This shows disregard for secondary conservation areas and also presents a liability to the city. Johnson Lake is already facing, and it is directly downhill from the parcel, it's already facing $1 million of needed repairs. The green zone has rewilded and become a haven for a diverse array of wildlife. Amending the future land use map would cut the amount of recreational land in Snellville by over 30%. Deep professional and personal ties exist between the owners of this land and many of our officials. We fear that this may give some undue favor, and we hope that it doesn't, but that's something that has been brought to our attention and that we were asked to include here. And citizens are asking to be assured that the votes are impartial. Now, my time is up, and I ask that I may be granted opportunity to do a wrap-up.
Well, if I give you more time, do you want more time?
I'm happy to allow them more time to speak, however much time. Refer to the planning commission.
5 minutes.
Yes, sir. Thank you so much. We understand that conceptual site plans require only limited studies and surveys due to upfront costs that may not be recouped should zoning be denied. But doing things in order transfers the risk from developers and landowners onto the city and its residents, which is not acceptable here. At a minimum, the city should insist that developers demonstrate due diligence to create accurate site plans that take into consideration the land's natural features before giving a blanket approval to rezone. We request that recommendations and approvals be contingent and conditional on land suitability, and if the land is unsuitable for RS5 development, given its secondary conservation areas, zoning would revert back to the original RS5, and RS30, and you can see these bullet points here. We also have identified proposed alternate uses for this land, and you'll see bullet points 1 through 6 here, in which we are truly not trying to withhold this landowner's ability to use their land. We only wish to protect our neighborhood and its environment from permanent harm, maintain the structural integrity and value of our homes, as well as preserve the unique character of our beloved city. We fully recognize that the landowner can develop the land as currently zoned at RS 30, and we understand their wish to sell the property. But there are other ways to accomplish these goals while also minimizing the impact on surrounding neighborhoods and without sacrificing this treasured green space forever. In conclusion, the Summit Chase Country Club property is not just another vacant piece of land. It is an icon of Snellville and a gem of our neighborhood. It is ingrained into the identity of the landscape. It is a riparian buffer along the Big Haynes Creek watershed, which is a federal watershed, and home to vast arrays of flora and fauna, unique granite outcroppings, and pristine forest habitats that protect local wildlife. For the last 40 years, it has been an enclave and recreational respite from urban life for the entire community. As much of this land as possible should be preserved for future generations. Failing to give serious thought to conservation is unconscionable. This proposed development would not serve the interest of Snellville residents, both those nearby and those in the city at large. Furthermore, residents should not have to defend themselves from potential harm brought by profit-driven developers. Instead, the developer should have the burden of proving that it would do no harm and instead benefit the existing community. Rezoning from RS 30 to RS 5 might benefit the builder, who described this as a speculative development and part of its effort to add neighborhood tracts to his portfolio. But it will hinder the ability of future generations to thrive here. Given the numerous concerns brought forth by surrounding residents and the builder's incomplete and inaccurate application, we, the nearly 500 residents, visitors, and supporters of this effort, urge the Planning Commission to recommend the City Council deny the builder's request to rezone the land and amend the future land map. What we have heard echoed over and over again by community members is that they feel city officials have failed to hear their voices on development matters in the past. Please prove those impressions wrong. Please prove that the principles of the 2045 Comprehensive Plan are not just platitudes, but have real-world impacts to benefit Snellville residents. We beg you to hear our collective voice and help us preserve the character and natural resources within this long-standing cherished oasis. And we thank you in advance for serving the interests of the existing residents who have invested in a true low-density neighborhood. We also have 468 signatures, including those of many people behind us, collected on change.org in opposition to this rezoning, and we have those available for you if you would like to review them. I thank you so much for your time this far.
Thank you.
Mr. Chairman, there's 57 seconds left if anybody else wants to speak in opposition.
Would anybody like to come forward? Since I've granted an extra 5 minutes, our attorney has suggested there's 57 seconds left if anybody else wants to speak up.
I'll speak up. My name is Fran Armstrong. I live on Classic Drive. I live in the cul-de-sac. I was here with my husband and my son, who had to go home to take a test for Georgia Gwinnett College, where he's a student. And we were 10 minutes late to this because of traffic. We couldn't get onto Rosebud. We just sat there and turned, and I hope the committee goes out and drives around our neighborhood and tries to leave Classic Drive and get onto 78 and to get onto Rosebud before you vote or decide, because it's already really hard. And I don't know what 150 people and all their friends are going to do. Okay, that's all.
Thank you. Any time left?
22 seconds.
Okay. Anybody got something quick and sharp to say? 20,
Mine is kind of a visual
22
thing.
seconds.
John Fonda, 2989 Deer Valley Court, and I've lived there for 26 years. Just look at that map. What do you see all around? You see lots that are of pretty significant size. It's pretty easy to see. That's just the visual. It's not getting into too much, but look at the size of these 150 lots that they want to throw in this little area.
That's time, Mr. Chairman.
How can you possibly
Thank you, sir.
consider letting them go to an R5?
Would the applicant like to speak in rebuttal or address concerns presented? And you have 5 minutes or 6 minutes and 5 minutes and 11 seconds. 6 minutes.
No, with the additional time, it's 11 minutes and
Oh,
11
you now have
seconds.
11 minutes.
Hopefully I won't take
Have at it.
all of that time.
Did you bring dinner?
I've been told I'm best in small doses, so I'll try to keep to the point. I think, I appreciate the comments and concerns from the neighbors. I will say, not just to pat ourselves on the back, but I do hope there's at least some appreciation. We do understand that development in your backyard is never pleasant. We do understand that's disruptive to your day-to-day, and we understand how important it is to people, because for a lot of folks, your home is your biggest investment, and you've lived there for a long time, and there's all sorts of connections there, and there's I won't go into the detail about the history of the Britt family and the property and all the efforts and good times on that property over the years, but did want to talk about one thing that I've noticed recently in the housing market is sort of a transition or an evolution, devolution, some people may say, but to different style home products. And I think what I've seen and what the market is showing is a lot of the new construction is smaller lot homes, but a focus on the buildings. A lot of people would prefer to have higher end finishes on the inside, more accessible, intuitive floor plans, and especially young buyers, I think share a lot of those preferences. And so what the proposed development does is provides that type of housing diversity that is called for in the comprehensive plan, and not just in the town center. That's a citywide land use policy of diversifying housing. And so we think there's an opportunity here with buffers and with enough, call them quality controls, to make sure that the development that goes in on the property is high quality, is something that's accretive to the neighborhood, is something that raises property values, and is something that everyone we hope would be happy with and proud to live nearby. We understand that's a high bar to chin, but that is what we're trying to accomplish. I'll also touch on, one of the advantages with a rezoning when it comes before the Planning Commission, of course, council, is the opportunity to impose zoning conditions. And staff has already recommended several zoning conditions on the property. That includes a site plan specific condition. So if approved that way, we would be obligated to develop the property in accordance with that comp plan, and deviations have to come back before council after recommendation from the Planning Commission. But what there are opportunities for are to codify some of the aspects of the development that we've proposed, such as the buffers, the minimum home sizes, things like that can be specifically tailored to this development to try and provide those assurances of long-term quality and compatibility, that to use that word again. Another item that we talked about in the community meeting and that we've thought a lot about on the applicant team side is the fact that we designed it to try to save the amenity area. We think there's something special about the clubhouse and the pool and the tennis courts, and we'd like to try to keep those, and that's why the development was designed to keep those in place. If the property were developed under its current RS30 zoning, then it's not a public hearing process. It's LDPs and do you comply with the code when it's developed as is, and there's not buffer requirements there. There's not obligations to utilize the existing amenities area. Or one thing that we've talked about specifically was trying to provide access to these surrounding communities. And so I think with some coordination, we envision and think it would be possible to achieve a situation where this amenity area would be the primary recreation and amenity area for the residents in the proposed community if it's approved. But one option would be to have a certain allotment of additional licenses or memberships that people in the surrounding communities, which you wouldn't want to go too wide, but I think the immediate surrounding areas, Summit Chase, I think naturally. But, to say at your option, you can have an amenity access for some fair price that we could try to work out. It's not like you would charge more for people who don't live in this community to access them, things like that. But to try to, just because that was specifically discussed at the community meeting, we think there's a way to do that. And I think a zoning condition could be an appropriate way to hold us to that, because as y'all know, zoning conditions are effectively part of the zoning ordinance. They're enforced just like the provisions of the zoning ordinance. But with those details added there, not to restate my entire presentation, but would submit that given the entire context and the area and sort of the unique physical characteristics and shape and size and history of the property, that the proposed development, I would submit to the Planning Commission, is reasonable. It is in line with the policies of the comprehensive plan, and it is compatible with the surrounding development, and would respectfully request your recommendation of approval, and we are agreeable with all of staff's recommended conditions.
Thanks, sir.
Yes, sir.
Before you go, do commissioners have any other questions for the applicant? I want to make sure I get that in tonight. We're good then. I now announce that the public hearing portion of this meeting is over. I will now entertain a motion regarding the land use plan for, let me get the number correct, LUP 24-02, is that correct?
My motion is to deny LUP 24-02.
Do I have a second?
I will second that motion.
Do we have any discussion or need for consideration?
I just want to point out that I think that the planning department and the developer mischaracterize the 2045 land use plan and defining the existing character description. While they are single-family homes that they've proposed, they are not estate residents on generous lots, and therefore this proposal doesn't meet the quality and character of the existing development, and I would prefer to see something come back before us, either develop it as the current zoning or maybe submit it as an RS-15. But even though they've extended the lots above RS-5, it just doesn't meet what's there.
Thank you. Any other questions, comments, considerations? It's time for a vote, because we had a second, is that correct? Okay. All in favor of Michael's motion to deny?
Aye.
Unanimous? I thought I asked you to be quiet. I'm looking for something. I don't know where it is. All right. Yeah, I know. I now need a motion to adjourn. We have no new business. Yes, sir.
Just want to let everybody know, it'll be basically a month from now, and mayor and council, that we'll hear the final one. So that's where the gavel will swing. So make sure you're here. If you have any questions regarding this process that you need, please reach out. I'm accessible. And I'll be happy to help you along the way. Anything you need as far as information, clarification, or access to anything we have. So that's all I've got to add. Thank you.
Thank you, sir.
Motion to adjourn.
Second?
Seconded.
Vote? Thank you, everybody, for being here.